to lecture 10. The lecture follows from Richard Carnan's lectures on contractual interpretation, and the topic we're tackling on today is categorization. The text of agreed document between that parties conclude is, of course, the starting point for establishing what the parties have agreed to, what their rights and duties are under the contract. However, there are circumstances where parties will agree in such a way that it's not possible to determine the substance of their agreement from the document itself. And there are two sets of circumstances where this might happen. One is categorization. So where the substance of obligations between the parties is such that the nature of the agreement does not necessarily reflect what the actual intention of the parties is, but it's consistent with the rights and obligations that the parties have established in law. And the second one, which is different from the first, is sham, and we'll start with that one first. It's not very common in practice. I should say that, first of all, I can't get the mics to work again, so can you all hear me? Okay, good. This is all a bit odd. Oh, this is promising. Good. Secondly, this is a somewhat unusual topic. It doesn't have its own book. It doesn't have its own article. So what we're going to do is to look at some cases and try to determine what the courts have been doing when approaching documents and establishing the rights and duties of the parties. I think it's a hugely important topic in practice, and one that is currently evolving still. The interesting questions that we could look at are whether the court's approach is changing to contractual interpretation in general, or whether we're looking just at different aspects of the way in which courts approach documents drafted by the parties. Is categorization completely different from contractual interpretation, which seems to be the prevailing view, or is it that the courts say that they're merely in categorizing rights and duties between the parties to the transaction, but as a matter of fact, they are twisting the words that parties have set out in the document, and they are redrafting parties' transactions. So I understand that you have had a good look at contractual interpretation with Richard. So hopefully what we'll look at today, it will be very familiar. And also, conveniently, we'll look at some cases, many of which you have looked over the course of the term. So this lecture, hopefully, will also act as a form of revision. But we'll look at the cases that you already looked at before by asking different questions. Rather than looking at the substance, trying to distinguish between the different rights and duties, we are asking how the courts approach those transactions. Inevitably, we'll have to look at some questions of substance, but the overarching goal is to look at the approach that the courts have taken. So a methodological lecture, if you like. And it's relatively light, I hope. So it should be a reward for you making here on this dreary morning. Well done for making it in this weather, by the way. I know it's been a challenge for a number of people. So I hope it's going to be relatively light. The if you do have any questions throughout, there should be plenty of time for me to answer them too. So we'll see how it goes. So first of all, we need to consider the circumstances in which what the parties have agreed to is really does not reflect their actual agreement. And it's useful to look at the case Snook and London West Riding Investments. And this case is a case where sham was not found, but courts have considered whether there was a sham. The first instance judge did think there was a sham, and the minority judge, Lord Denning, Master of the Rolls, thought there was a sham too. But the majority did not. And it's interesting to look at it. So facts are somewhat long, but useful for our understanding of what's happened. So Mr. Snook bought a car, or rather acquired it on hire purchase from a company called Totley. He paid a substantial amount by way of deposit. The car was worth about £900. He paid about £700. The remaining sum was going to be spread over a period of 12 instalments, I think a year, and he was going to be paying off until his full rights were acquired by him, and the title would be transferred. As you know, in hire purchase agreements, the nature of that agreement is such that the financier, Totley, holds title to the car. So Totley is the absolute owner of the car, whereas Mr. Snook acquires... Does Mr. Snook acquire any proprietary rights under hire purchase agreement? Does anyone remember analogy with perhaps Shogun Finance? Does the hirer under hire purchase agreement acquire any proprietary rights? None whatsoever. None whatsoever. Totley was the absolute owner of the car for the duration of the hire purchase agreement until such time as the conditions under that agreement were fulfilled, until the price would be paid off. So Mr. Snook paid 3 instalments, and then he came across a leaflet advertising that he could raise finance against the car that he had hired on hire purchase, and that the finance was to be arranged by Otto Finance. And he decided to proceed. So he decided to enter into refinancing agreement using the car as a means of raising more money. So he wanted to raise more money for whatever activities he wanted to undertake. And then a series of documents were exchanged. So we need to look at them because they're quite important for the case. So first, there was an agreement that Mr. Snook was provided a form, a blank form provided by Otto Finance. And on that form, on the top part, Mr. Snook was to sign that he sold rights to Otto Finance, subject only to lien of Totley, the financier. The document was addressed to his original financier, Mr. Totley, not Mr. Totley, the company Totley, and so this is why it was formulated addressing Totley. So I have sold my rights to Otto Finance subject to your lien, which they will discharge. Will you please inform Otto Finance how much you require to settle my obligations to you and to pass title absolutely to them in the vehicle? Now, can we just pause here and can we just consider from the perspective of what you've learned throughout this term, whether the use of lien in this sentence was legally accurate. It's not relevant for the case, but just something to be quite critical about when parties formulate documents and write various things in their transactions. So I have sold my rights to auto finance. What rights did Mr. Snook have under hire purchase? No proprietary rights, but what sort of rights? I mean, he had some sort of rights, didn't he? Personal rights, right. Personal rights. He also had a possessory right in the car. Okay. Now, possessory possession, as you know, does count as right of property and as good as ownership against everybody except those who have better rights. Of course, in this case, there was an entity that had better rights, which was Totley, the financier. The financier was the owner of the car. Mr. Snook only had a right to use the car until he paid off the finance, and at that point he would have acquired title to the car. But until then, he had no rights. So this document is a bit odd, because assigning rights to auto finance, there are not many rights that he can assign. And the purpose of the transaction wasn't for Mr. Snook to give auto finance possession, the use of the car. It was only to raise finance. So Mr. Snook wasn't passing possession, rights by means of possession to auto finance. It was an odd formulation in this document. And also, addressing Totley, note the second oddity. The document said, I have sold my rights to auto finance. So sold my rights meaning I've transferred all my rights to auto finance, subject to your lien. Of course, lien, as you know, is a form of security right. Right? So, did Totley have a security right? No. Good. Totley did not have a security right because, why did Totley? Yeah, they were property owners. They held title to the car. Why can we be so sure that Totley had no security right and Mr. Snook could not grant security right to Totley by virtue of hire purchase? It's very, very obvious. Goes back to what we just said a second ago. Mr. Snook had no rights in the car, no property rights. Mr. Snook could not grant, therefore, a proprietary right to Totley. So this first document was formulated in an odd way, but this is what parties do in transactions. There are various forms to be filled in. They're meant to be standard blank forms. They're meant to work for a number of transactions. And it is then for the courts and for us to establish what actually the rights and duties were under those documents that parties sought to establish. So that's the first document. The document, as I said, was addressed to Totley, but it was never passed to Totley. It stayed at the premises of auto finance for whatever reason. So Totley knew nothing about it all. And then there was a second agreement, second document that was signed between Mr. Snook and auto finance. And in that agreement, Mr. Snook agreed to obtain finance from auto finance and to have the car again on hire purchase. So the agreement was that Mr. Snook would not have property in the car. Now, ordinarily, the title would vest in the finance provider. But in this case, the additional complication was that auto finance was not acting as a principal. So auto finance was acting for the true financier, London West Riding Investments. They were an agent for London West Riding Investments. But as you know, that's fine, even if London West Riding Investments were undisclosed principal, auto finance as an agent, acting within the scope of actual authority could bind the principal. So the second document was purporting to conclude a hire purchase agreement between, in fact, Mr. Snook and London West Riding Investments. And the document also included an express statement that property in the car would vest in the financier in London West Riding. The second form concluded there were various blanks, and Auto Finance filled in those blanks by providing information about the cost of the car and how much money would be payable by Mr. Snook to the financier. And those figures were not, they were plucked from thin air pretty much. There was no basis for them, but they were filled in nonetheless. Auto Finance then duly paid off Totley. So Totley, the original financier, was paid off. And a sum of money, just over £100, was paid to Mr. Snook as a form of finance, because that was the whole purpose of Mr. Snook undertaking this entire transaction, seeking refinance. But then sad things happened. Mr. Snook lost his job and fell behind with payments. He left his car in a car park, and he came to return to see there was no car. The car was seized by the agents of Auto Finance. Now, when he discovered it, he was late by 2 payments, so he was late by, I think, something like £30. 30 or so. He discovered it. He managed to find some money, so he went to the financier and offered their arrears, but it was too late. They refused to accept it. And they sold the car already. They sold it for £500, even though the car was worth £700. So Mr. Snook was annoyed and sued the financier for money he hadn't received for the price that they obtained. That was the balance what would be owed to him to reflect the rights that he had in the car. So he sued for conversion or money he hadn't received. So that's how the claim got to court. The question was, what sort of transaction was it? So Mr. Snook argued that the documents that he signed were a sham. That there was, in fact, no hire purchase. What he had was a loan from London West Riding, and the loan was secured on the car. Now, think about it. How is loan different from hire purchase in this context? And why did it matter? Why was it so important for Mr. Snook to insist that the effect of the documents was that there was a loan secured on the car, as opposed to hire purchase? Think about where the property rights lie in the car. If it's hire purchase, then title in the car is with the financier. In this case, London West Riding Investments. Mr. Snook, as a hirer, only has right to use personal rights under the agreement. If he can show that this is a loan secured on the car, who's the owner of the car? Snook, Mr. Snook. Because his line of argument is that title, the effect of the documents was that title really vested in him, Mr. Snook, and London West Riding had a security right in the car, securing the repayment of the loan that was made to him. Now, there are 3 lines of arguments in this case, and we don't need to look at all 3. One was to do with a specific statutory regulation of hire purchase at the time, not relevant to us. The second one was to do with whether Totley passed title to Mr. Snook or London West Riding. Again, not essential, but the third one is important for our purposes, which is to do with the question whether the documents were really a sham. So whether the transaction was really a loan secured on the car and not hire purchase. Because if it were a loan secured on the car, it would be void. Now, it would be void because Mr. Snook, as an individual, unincorporated entity, when granting a security right in writing, would have to have that security right registered, not in the company's house, because it's not a corporate entity, but in High Court under the Bills of Sale Acts legislation. You don't need to know much about Bills of Sale Acts, you don't need to know much at all, but it's useful to know that they exist, and in order for security to be valid, in some cases such as Snook, there is the Bills of Sale legislation requires registration, and if not, so Bills of Sale Acts require registration, and if it's lacking, then the security is void. So the judge in the first instance decided that, in favour of Mr. Snook, that there was in fact a loan provided by London West Riding Investments, and that in fact Mr. Snook granted a security right. The security right was not registered at the High Court and therefore void under Bills of Sale Acts, which meant that London West Riding, as the financier, was an unsecured lender because they lent a sum of money to Mr. Snook, but the security right in the car was void. Now, on appeal, Mr. Master of the Rolls, Lord Denning, felt sympathy for Mr. Snook, and it's easy to have sympathy for Mr. Snook in these circumstances. So Mr. Snook got some sympathy from Lord Denning, and Lord Denning sided with the judge in the first instance, saying that there was a sham. Because, first of all, the documents that were concluded that Mr. Snook signed were in fact full of fictitious figures. The first document was never delivered to Totley. The second document of hire purchase contained fictitious information. So the result of that was that Auto Finance never became owners of the car. And since they never became owners of the car, they had nothing to transfer to their principal, London West Riding Investments, nemo dat rule. You see how I say that this is a revision seminar, lecture, that it does really require what you've learned this term. So, who made the loan then? Of course, Mr. Snook dealt with Auto Finance, but the only entity that could potentially provide the loan was London West Riding Investments. And so the security right that could have been granted would have been in favour of London West Riding Investments. Of course, London West Riding Investments were innocent because they didn't negotiate the transaction. So how could you say that they should suffer the result of those fictitious documents that Snook and Auto Finance entered into? And here is where agency law becomes important, because Auto Finance as an agent was acting on behalf of London West Riding, and acts of an agent acting with actual authority, as you know, bind the principal. So even though London West Riding was not party to the documents, they should suffer their fictitious character, the consequences of their fictitious character, in the same way as Otto Finance would. So it did not matter to Lord Denning that they themselves did not negotiate the transaction. But the majority, Diplock and Russell, didn't agree. Because for there to be a sham, for us to be able to say that a transaction is a sham, that the documents are a sham, we need intention on behalf of both parties, Shami and Shmer, both parties to the sham transaction, to have shamming intention. And if you don't have the shamming intention, then there can't be a sham. So there's this very famous dictum, and it really is famous. It's quoted in many places by Lord Justice Diplock, so it warrants us looking at it more scrupulously. He says that, I apprehend that if it has any meaning in law, it means acts done or documents executed by the parties to be the sham, which are intended by them to give to third parties or to the court the appearance of creating between the parties legal rights and obligations, different from the actual legal rights and obligations, if any, which the parties intended to create. But one thing, I think, is clear, he says, in legal principle, morality on authorities. I really don't understand why morality is there, but there we go. There's nothing moral about law. There, said it. But one thing I think is clear in legal principle, as we should say, and the authorities, that for acts or documents to be a sham, with whatever legal consequences follow from this, all the parties thereto must have a common intention that the acts or documents are not to create the legal rights and obligations which they have appearance of creating. So, according to the majority, Lord Justice Diplock and Russell, it was not possible for London West Riding to be party to the sham, and there could not be any sham, because London West Riding never expressed an intention that there could be a loan. And for a transaction to be a sham, there must be common intention between the two parties, clearly showing that both parties intend for the transaction to be, for example, a loan, but the transaction is structured in the documents in such a way that it looks as if it creates a different transaction, for example, a hire purchase. And in this case, according to the majority, there was no evidence that London West Riding, which is the true principal here, the true provider of finance, had expressed intention to provide a loan. They didn't provide any intention, there was no intention shown, but that was enough for the majority to say there can't be any sham. An intention of Otto Finance, interestingly, there was no question of imputing intention of Otto Finance to the principal. So there was no question of that, because they could have gone down this way, but they have not. And I think that's right, because the ultimate finance provider, the person who provides finance, London West Riding, were the source of actual authority to Autofinance, and they expressed an intention at some point before Autofinance started entering into those agreements and signing the documents, what sort of transaction this was going to be. And there was no evidence that London West Riding showed intention to enter into a loan agreement, and therefore there could be no question of there being a security right. But what is important is, from this case, is that establishing a sham requires intention of both parties. So in what way can sham be fraudulent? It's fraudulent on third parties. And it's very rare in practice, because it's rare to find that both parties are fraudulent and seek to commit a fraud on behalf of a third party through a transaction, through a set of documents. So shams are rare. But one interesting thing that comes from this discussion is that for us to be able to say that there is a sham, we need to look at the documents that the parties have signed and look at the intention, to establish the common intention. Now, think about the way in which you establish intention in contract. So contractual interpretation requires us to look at the document itself. I'm sure Richard would have emphasized this point, that to establish the intention between the parties, we look to the intention that parties expressed in the agreement, usually the document. But here, of course, the documents show different intention and common intention. So in order to determine that there is a sham, we need to look outside the agreement. So in order to establish and to be able to say there is a sham, we must look to outside evidence, outside the documents, extrinsic evidence, extrinsic to the agreement. And we may well look into the post-contractual conduct, any background information. So determining whether there is a sham requires common intention between the two parties to the sham, but it also allows us to look at extrinsic evidence to the agreement, which is different from contractual interpretation. So the way in which courts approach shams is different to the way in which courts construe intention from contracts, from agreements. So, apart from shams, parties are free to establish in the agreement whatever rights and duties they wish to create. The structure of the agreement they can freely determine. So, is it so easy? Can we just now all go home? Well, it's not quite so easy. So how do we determine the substance of the agreement? What factors do we take into account? So first question, which is an important question, is do we look at the economic effects of rights and obligations that parties created? And an interesting case that illustrates the approach that courts take is Yorkshire Railway Wagon and McClure. This is an old case which involved a railway company and rolling stock, so trains. So the railway company needed some money, but it was a company established by an Act of Parliament, and under that Act of Parliament it had very limited powers of borrowing. so it could not borrow. So it had an idea to sell the rolling stock trains, rather than borrow money against security of the stock that they had. The idea was to sell the rolling stock they had to another company, wagon company, and to lease it back, take it back on hire purchase. The hire purchase was structured in such a way that it lasted 5 years, and over the course of that term, the rents that railway company would pay to the owner of the rolling stock, to the wagon company, would amount to the entire price of the rolling stock. Plus, at the end of the 5-year agreement, railway company, Yorkshire Railway Wagon, railway company had a right to purchase the rolling stock and become owner of it again. So the economic effect of the transaction was so that the railway company could acquire finance using the assets they had, the trains, the locomotives and so on. But rather than borrowing from a bank and granting security, right, inevitably, because the bank, any lender would have asked for security, no doubt, they decided to sell the stock they had and lease it back. So it was a clever transaction to overcome the restriction in the Act of Parliament, the restriction of borrowing. And the court was faced with the question whether the documents that parties concluded reflected really a hire purchase agreement, or were they really a disguised borrowing? Because economically, the economic effect was that of secured lending or secured borrowing from perspective of railway company. So the judge in first instance decided this was disguised borrowing, and he decided so by looking at the economic effect of the rights and duties that parties have created. But the Court of Appeal disagreed, and the decision shows you the way in which courts in England approach transactions between the parties, how lax courts are when approaching transactions. Rather than looking at the economic effect, Lord Justice Lindley said that parties were free to structure their transaction in the way they wanted. And sort of midway through this first paragraph, Lord Justice Lindley says that I am satisfied that the purchase and hire transaction was the real transaction. It was not intended to be a blind or a mere blind or cloak for something else behind. It was a transaction substituted for another, but bona fide substituted. And it was intended to be acted upon according to its purport and apparent effect. Now, this is a bit, there's somewhat bit of inconsistency here, because he says it was not intended to be a mere blind, it was a transaction substituted for another. So he says that, in effect, to me, what he says is the transaction was a different transaction to what they were trying to achieve, but it was bona fide, so it's okay. They were not trying to be fraudulent. But the words used are not particularly fortunate. But what's important is the general approach that the Court of Appeal and Lord Justice Lindley took, which was to look at the documents that the parties signed and ask first the question, is this a sham? Is this a cloak to conceal a different transaction? Are the parties entering into a hire purchase agreement on the face of the documents, but really, in truth, concluding a secured loan agreement? And in the second paragraph, he says, if it were a mere cloak or screen for another transaction, one could see through it. But once come to the conclusion that it was a bona fide, a real transaction between the parties, intended by both sides to operate according to its tenor, there is no mode that I know of holding it illegal unless you find it prohibited by some act of Parliament. So if the common intention between the parties is bona fide, the courts will give effect to that intention. So, in other words, just because the documents that the parties create can be read as, on one level, creating economically a secured lending transaction, but on the other level, creating, on the face of the documents, creating hire purchase transaction, just because those two meanings are possible to infer from the documents, it doesn't mean that the court should take the route of the secured loan transaction if what's on the face of the document is bona fide. That means concluded in good faith, and it reflects what both parties intend to create. It reflects their objective common intention. So just because, in other words, just because the transaction between the parties economically amounts to another transaction, the courts will not look at the economic effect of the transaction. The court will not dig deeper behind the words of the document to look at the economic effect of the transaction if, on the face of it, the substance of the obligations is such that both parties have agreed to it and the transaction has been entered into in good faith. There is also an important dictum from Welsh Development Agency, a case that we've looked at before and it will come up again later today, from Lord Justice Staunton, who emphasised that even when we are looking at the statute and interpreting what words in the statute mean, we are looking at the legal nature of a transaction and not the economic effect. This is quite important because in a number of jurisdictions, transactions, particularly transactions involving finance, are classed depending on their economic effect. Usually, economic effect of security rights. So if a transaction has a legal nature that amounts economically to a security right, to secured lending, it will be classed as a secured lending. That's the very basis of Article 9 of Uniform Commercial Code, of Personal Property Security Acts, which we referred to briefly in the lectures on security rights. But English courts are very much keen on determining the legal nature of transactions and not the economic effect. And the way in which courts do that is by looking at the documents and asking two questions. Is the written document a representation of the agreement of the parties? If not, it's a sham, a cloak or a device, as Staunton Lord Justice says in Welsh ex vinco case. But if it is the true representation of what the parties have agreed, then we look at the written agreement and we seek to ascertain from the terms of the agreement whether it amounts to a transaction of the legal nature which the parties ascribe to it. So we look at the substance of the transaction and not the form. There is the emphasis of the substance of obligations and not the form is a very old thing for courts to do. In Helby and Matthews, which is another case that we'll refer to later, House of Lords case, Lord Herschel said that the substance of the transaction, it is said that the substance of the transaction evidenced by the agreement must be looked at and not its mere words. And that's fine, I agree. But the substance must, of course, be ascertained by a consideration of rights and obligations of the parties to be derived from a consideration of the whole agreement. So what the courts are doing, if they're not looking for a sham, if they establish that there is no sham, the courts focus on the substance of rights and obligations that the parties have concluded between one another. This is different from trying to determine the nature or guess the nature of the transaction. The nature of the transaction is a sort of secondary thing. The primary objective of courts' approach is to determine what rights and obligations parties have between one another concluded. And this approach is referred to in the Agnew case, or otherwise known as Brumark, by Lord Millett as the so-called two-stage approach. So when the case involved fixed and floating charges, characterization of transactions as fixed or floating charges. And when courts approach an instrument and a document, they are faced with a question whether the document creates a fixed or a floating charge. First of all, the courts must construe the instrument and gather what the intention of the parties is from the language that they have used. The objective at this stage is not to discover what the parties intended to create, whether they intended to create fixed or floating charge, but only to ascertain the nature of rights and obligations that they sought to create. So, if it's a floating charge, did the parties intend that the chargeur would be able to use the assets in the ordinary course of business? And only once they've established the nature of the obligations, the court will look at how those rights and obligations measure up against the recognized categories in law. And that's second stage, which is a matter of law and not contractual intention. That second stage is referred to as categorization. And we look at the difficulties, the practical difficulties that courts are faced with when categorizing transactions after the break.